All right. Are we ready? Good morning. We're happy to have, thank you. We're happy to have you here today. We think you'll have a very all right, interesting conversation going on here about stuff that needs to be learned. Are we ready? So I'm Alleen VanBebber. I'm the current president of the league, we're happy to have, local league. Thank you. And we're happy to have you here today. This is our program chair. You'll have a very Jessica Tripe-Rowley. Interesting conversation going on here about be stuff that needs to be learned. Are we ready? So I'm Alleen VanBebber. I'm the current president of the league. We're happy to have local league.
Well, good morning, everyone.
We're happy to have you here today.
This is our league members and community friends and guests. Thank you so much for spending your Saturday morning with us. As a reminder, before we get started today, our League of Women Voters, we are a grassroots nonprofit organization grounded in nonpartisan policy. LWV neither supports nor opposes any candidate or political party at any level of government. Our mission is to defend democracy and to empower voters, and our programs and events actively try to include all party affiliations and different points of view. While the League is nonpartisan, we are political. Our local league has been actively involved in public policy at federal, state, and local levels for 74 years, as evidenced by our long-standing position statements. Today's program, as Alleen said, is merit selection of the Kansas Supreme Court. And this is an area that it's a critical issue, but often overlooked or intimidating to people because they don't understand how to cast a vote on something that is related to our judiciary. So in August, Kansans will be voting on a proposed constitutional amendment that could change how the Kansas Supreme Court justices are selected. This matters. Former Kansas Supreme Court Chief Justice Lawton Nuss and Logan Stenseng, the Civic Engagement Manager of Kansas Appleseed, will explain how Kansas currently elects or selects Supreme Court justices, what the proposed constitutional amendment would change or could change, and considerations for you to go home and think over before you cast your vote in August. Now, if you do have questions for our panelists, and I hope you will, please write them on the cards that you received and hold your card up so someone can come and collect that, and we will ask them later in the program as time permits. Before we begin, I would like very much to introduce our speakers. Logan Stenseng is a passionate community organizer that helps Kansans get involved in civic engagement on issues that ensure all Kansans thrive. He was raised in El Dorado and holds a bachelor's degree in public administration and public policy from the University of Kansas. He has held positions in nonpartisan voter registration, organizations like kansasvotes.org and the Campus Vote Project, and regularly engaged in nonpartisan voter registration and get out the vote efforts since 2016. Prior to his current role as Civic Engagement Manager, he worked for 5 years as the policy coordinator for Thrive Kansas on policy advocacy issues impacting rural families and early childhood issues in Kansas. His current employer, Kansas Appleseed, which many of you are familiar with, is a nonpartisan nonprofit working toward the future where all Kansans have resources that they need to flourish, raise healthy families, participate fully in their communities, and benefit from fair and effective systems of justice. Logan assists Appleseed's statewide advocacy efforts in Topeka and across Kansas, focusing on civic engagement. Logan is a current member of the Kansas Future Fellows. He has served as a board member of Kansas Civic Network, the Campus Vote Project, the Kansas Head Start Association, and other local task forces. Logan loves everything Kansas and enjoys spending time with friends and family, volunteering, woodworking, and is a proud father to his cat, Saru. And very importantly, our special guest, former Chief Justice Lawton Nuss's career reflects a steadfast commitment to public service, spanning military, legal, judicial arenas. Fourth-generation Kansan, born in Salina, Nuss earned a Bachelor of Arts in English and History from the University of Kansas through a Naval Reserve Officers Training Corps scholarship. Upon graduation, he was commissioned as a second lieutenant in the United States Marine Corps and served 4 years as a combat engineering officer with the Fleet Marine Force Pacific. After his military service, he returned to the University of Kansas and used the GI Bill to help earn his Juris Doctor. Nuss practiced law for 20 years at the Salina firm of Clark Mize Linville Chartered, handling a broad range of civil and criminal cases. His peers recognized his legal ability and ethics with an AV rating from Martindale-Hubbell, a national organization's highest distinction. In 2002, Governor Bill Graves appointed Nuss to the Kansas Supreme Court. He became Chief Justice in 2010, overseeing nearly 300 judges and 1,600 employees, handling approximately 400,000 cases annually. Beyond the bench, Nuss has been actively involved in community service. He served as chairman of the Salvation Army Advisory Board and was a member of the Board of Trustees of St. John's Military School. He co-chaired the State and Federal Courts Committee of the Kansas Bar Association. After retiring from the Supreme Court in 2019, Nuss continued his dedication to the Veterans Affairs and public service. He chairs the board of directors of the Veterans Court Coalition and serves on advisory boards for National Veterans Justice Commission, the Veterans Legal Support Clinic, the University of Kansas Law School, School of Law, and he also chairs the Executive Committee of Alliance for Former Chief Justices, a nationwide nonpartisan group of 54 former Supreme Court justices dedicated to promoting the rule of law and judicial independence. Chief Justice Nuss is married to Barbara. They have 7 children, 14 grandchildren, and 1 great-grandchild, and I will greatly welcome Chief Justice.
Good morning. Thank you for the opportunity to speak to you today about the proposed constitutional amendment having to do a selection of your Kansas Supreme Court justices. The proposal to abolish our current merit selection system will be on your August 4 primary ballot. So let me start with a little bit of Kansas history. From 1861 to 1958, Kansans elected their justices. This? Better? Should I start over by saying good morning? All right. Let me start with a little bit of Kansas history. From 1861 to 1958, Kansans elected their Supreme Court justices. Then in the late 1950s, the famous or infamous triple play happened, and let me explain that scheme. Governor Fred Hall lost his bid for re-election, so he talked with his friend, who was the Chief Justice of the Kansas Supreme Court, and the Chief Justice retired during his term. So that's the first part of the triple play. then Governor Fred Hall resigned his position as governor. That's the second part. That meant his lieutenant governor moved into the governor's spot, and the new governor then appointed the old governor, Fred Hall, to become Chief Justice of the Kansas Supreme Court. Okay. Well, in 1958, shortly after this triple play, Kansans went to the polls and they voted to amend their constitution and to replace elections with merit selection. More than 280,000 Kansans, 60% of those who were voting, said yes to change, and we've had this system for the last 68 years. Let me explain the merit selection system. The 1958 constitutional amendment created a Supreme Court nominating commission that's composed of one person from each congressional district appointed by the governor, so that would be 4. So we have diversity, geographic and otherwise, and they bring the viewpoints of the people in their district. The example I like to give is my grandparents were farmers out by Dodge City, and they might have a little different view on some issues than you folks in Johnson County. But both of you had representation on the commission. Then there is one lawyer in each congressional district who is elected by the lawyers in that district. So that's 4 more members. That gives geographic diversity, and it also gives the commission some people familiar with the law and what makes a good justice from various fields of law. Just a few examples. Some of these members have included plaintiffs, personal injury lawyers, and also those who oppose them in court, the civil defense lawyers. The commission's also included lawyers both from large firms and sole practitioners. It's included criminal defense counsel in both big cities and in small towns. So this is somewhat like the process of picking your heart surgeon before your heart operation, because I don't know about you, but I'd like to have some people who knew something about medicine to help in that decision. The chair of the commission is elected statewide by all the lawyers who are licensed to practice, so there's a total of 9 members on the commission. The commission then accepts applications for the justice position. The commission investigates all the applicants, then they interview all the applicants in public. Then in public, it votes for 3 names to be sent to the governor, and you can watch these interviews online, and you can later watch them because it's all archived. The Kansas Bureau of Investigation then does background checks on the 3 finalists. The governor's office does some more investigating. The 3 finalists are interviewed personally by the governor, sometimes also a prior interview by the governor's staff, and the governor then chooses the new justice. At the first statewide general election, the new justice is then on the ballot for a voters' retention election. The question is, do you keep them or not? If the justice is retained, the justice then serves until their next retention election 6 years later. In short, the emphasis throughout this process is on the quality of the applicants, merit, who will best serve Kansans on the highest court in our state. All right, let me give you my personal experience to show you how this system has worked. All right, in 1995, there was an opening on the Kansas Court of Appeals. Now, that is a court that's higher than the courts in your community here in Johnson County. You have a district court, then you have a court of appeals, then you have a Supreme Court, the highest court in the land. There was an opening for the Court of Appeals. And it also operated under the merit selection system until a few years ago when the legislature, by statute, changed it. But going back to 1995, with that opening, thousands of Kansas judges and attorneys received notice, and they were invited to apply for this position. To be eligible, you had to be at least 30 years old, licensed to practice law in Kansas and continuously practicing law for at least 10 years. So I decided I would apply. I filled out this lengthy application. I attached several writing samples. I listed personal references, and as the application required, I listed judges and fellow lawyers who were familiar with my legal work. I submitted to an investigation by the 9-member nominating commission and also went through their public interview. My 29 competitors did the same thing. After this thorough screening process, the commission selected 3 people from whom the governor could choose the next Court of Appeals judge. My qualifications were not good enough. I wasn't selected. Well, another Court of Appeals opportunity arose a few months later, and this time I competed against 27 other applicants. And after a complete repeat of this process, the application, the commission investigation, and a public interview, same result, I was not one of the 3 selected because I wasn't good enough. Well, because I was determined to earn a position as an appellate judge, I tried to improve my competitiveness. To hone my reading and analytical skills, I researched and I wrote several legal articles for publication, and I volunteered to write appellate briefs for other lawyers. And to sharpen my understanding of the law's application in the real world, I asked for and handled more trials in front of Kansas juries, such as yourself. To achieve a broader perspective of the law, I expanded my law practice to include additional legal fields. For example, I began to work as a special prosecutor, but I also defended those accused of crimes in some other court jurisdictions. I represented defendants who were sued in civil cases for personal injury, but in other cases, I also represented plaintiffs when I filed lawsuits on their behalf against their employers. Well, in my 3rd Court of Appeals application, and in that competition, 5 years later in 2000, I was selected from 22 applicants as one of the 3 people whose names would be submitted to the governor. My 2 competitors were a district court judge, a trial judge, and another lawyer. But after my KBI background investigation, the governor's own vetting process, and my personal interview with him, Governor Graves chose one of my 2 remaining competitors. I'm 0 for 3 if you're keeping score. So I began to work even harder to improve my legal abilities and my understanding of the law before the next vacancy. As I told Governor Graves later, 15 years later, that while I had been really disappointed, I knew enough about him to understand that he had chosen the person that he truly thought was the best. So it was still up to me to get better qualified. All right, well, 2 years later, in 2002, a vacancy arose on the Kansas Supreme Court. And saying it was because they knew my legal ability, 3 local Kansas trial judges urged me to apply. I did apply, and I competed against 17 other applicants. 4 were Court of Appeals judges, 6 were trial judges, and the other 7 were lawyers like me. Okay. Now, during this process, an entirely different trial judge called me to say he had been called by a member of the commission. They wanted to know all about me, my legal ability and my character. And I was surprised because this judge was not one of the judges I had chosen to list on my application as having knowledge of my ability. And frankly, I also was concerned because this particular lawyer was one that I had battled extra hard in a big court case only about a year or 2 before. And I was afraid that they were searching the entire state for a reason to ruin my chances. But after I talked with the judge, I was convinced that this commission member sincerely was just performing due diligence to see if I was worthy of becoming a justice. Well, after another full repeat of this nominating process, my name was again voted by the commission as one of 3 sent to the governor. My 2 competitors were a trial judge and another lawyer. And I wanted to let you note that at this time, the new commission chair was a career civil defense lawyer, which is the exact opposite of the previous chair's career as a plaintiff's lawyer. And if you know something about the law, you know that plaintiff's lawyers and defense lawyers are always on opposing sides of a lawsuit. They're fighting each other. And this time, after yet another KBI background investigation, vetting by the governor, and a personal interview by him, I was chosen by the same Governor Bill Graves who had rejected me in favor of someone else 2 years earlier. In my opinion, I was finally successful because I had steadily improved my qualifications during the previous 7 years. Okay. Now, as was mentioned, the proposed constitutional amendment does away with all this. But when you're comparing our 68-year-old merit selection system to pure election of justices that's provided in the proposed amendment, several fundamental features of our present system must be considered. First is the democratic feature. For nearly 70 years, our system has granted the equal opportunity to be chosen a justice to every Kansas lawyer and judge with at least 10 years' experience practicing law and who is at least 30 years old. Thousands, and I think it's over 10,000, are notified of every vacancy. And to have a chance of achieving such an important position, the person only needs to apply. Second, and more important to all Kansans, is the quality feature. As demonstrated by my own experience, equal opportunity to all means that many people will actually apply. And that obviously means true competition, one where politics and money fortunately play no role. But without such a competition that compares side by side the qualifications of numerous applicants, no replacement system can truly claim it will produce the best justices for Kansas. And recall, as I mentioned, that the new justice is subject to a retention election during the next statewide election after their appointment. My first retention election as a justice was less than 2 years later, in 2004. And there I received more than 679,000 yes votes from Kansans. In my last retention election, 2016, when I had now been Chief Justice for 6 years, I received over 600,000 votes from Kansans. So, all the voters of Kansas received full opportunities to decide if the Supreme Court Nominating Commission and Governor Bill Graves were doing good work. I don't know about you, but I would say that's democracy in action. Now, let me conclude this section by saying this. At no time during any of my 4 application processes did I spend any money for a campaign, much less solicit money for one. I did not make any campaign speeches or make any donations to any politician's war chest. I was never asked by any member of the 4 nominating commissions, nor by Governor Graves and his staff, about my political affiliations, or how I would or even might rule on a particular legal issue or a particular case. And there certainly was no reason for me to volunteer any of that. So I did not feel beholden to any person or any party once I was on the Supreme Court. My allegiance instead was found in my oath of office. I solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the state of Kansas, and faithfully discharge the duties of justice of the Kansas Supreme Court. So help me God. I kept this framed copy of my judicial oath on the wall by the light switch in my judicial chambers. So I would read this oath every morning when I came to work and I turned on the light, and read it every evening when I turned off the light and went home. This was a constant reminder to me of my duty. Now, Logan eventually will talk to you about the proposed amendment itself. As an introduction to that, let me say that 2026 is not the first year that I have known of such an attempted amendment. During the Kansas legislative session in 2003 or 2004, early in my time on the Supreme Court, I learned that a constitutional amendment to abolish the merit selection process was being proposed. So I went to the legislative committee hearing to hear how my former colleague, retired Justice Fred Six, testify about it. As I waited in the audience, there was a bit of a commotion at the door of the hearing room. And in walked the new Attorney General, a man you may remember, named Phil Klein. And he came to testify in favor of the amendment, and he arrived with a video cameraman to record his testimony. That proposed amendment was never able to be presented to the Kansas voters. Well, the next well-known political champion of doing away with the merit selection process was the man who became governor in 2011. You probably remember him, a man named Sam Brownback. Among other things, during his State of the State speeches to the legislature, he asked them to introduce legislation to do so. His efforts made national news. For example, they were featured in an article in the New Yorker magazine in 2016, and the article was titled, "The Political War Against the Kansas Supreme Court." Well, but like Phil Klein, Brownback's efforts were also unsuccessful. With him no longer in office, other politicians have now picked up this banner, and here we are. And now the moment you've been waiting for, Logan.
Not at all, no. No, the first time I heard Chief Nuss speak, I remember I got chills. It sounded like an underdog story movie when talking about the merit-based process. But can we do a couple slides? It should get to the August 4th one. One more. There we go. So I'm here today. I do also want to share. Basically, you know, in my bio, they talked about how I had been involved with nonpartisan voter registration efforts. The first table I ever registered voters at was organized by the League of Women Voters in Douglas County. Yeah. First time I had heard of the League as well, I was like, okay, it seems like a good group of people that are gonna show me the ropes, and they did in fact do that. So for this primary ballot, it's gonna be on August 4th, right? This question was put forth on this ballot by Senate Resolution 1611. That was passed in last legislative session, because in Kansas, if we ever have a ballot question that is addressing our Constitution, it has to pass the legislative branch, right? We don't have direct ballot initiatives in Kansas where we can do petitions and whatnot. Everything, if it were altering the Constitution, it must go through the legislature. So this was created by the majority of folks who passed that and, those politicians. And so there are some, we're going to go over the explanatory statement that will actually be on your ballot, right? They'll be on all of our ballots in this primary election, so that way you can look at the verbiage they selected. And we can also basically just talk through what a yes vote means and what a no vote means. And essentially, this election opens, if it passes, it opens the door to partisan statewide elections for all Supreme Court justices. It would permit candidates to engage in political activities, receive contributions, and hold office in political parties. And it eliminates the nonpartisan Supreme Court nominating commission. Oh, next slide, please. So the first line, and you don't have to read all of this. This is the first paragraph that will be on your ballot, where it's identifying the specific position numbers. So if we were to create these elections for justices, they would designate certain positions a number, and that number would have their year when it's election time, right? Now, the really critical part of this statement to read, and it will be a pattern throughout these statements, is if you look to near the end, the sentence where it says, "The rules applicable for such elections and the designation of position numbers shall be provided by law." Now, that provided by law section feels and sounds very innocuous, right? It's very vague. That's a blank check for the legislature to create the rules for those regulations, the rules for those elections. If it is not stated in 1611 or in this ballot amendment, when you read provided by law and we vote yes, we are essentially granting the legislature the power to determine how much can these candidates raise. Do they have districts? Do they not have districts? Do we have to have any type of qualifications? The only qualifications that this will not change, because it's in our Constitution for Kansas Supreme Court Justice, is that they must be 30 years or older, or like a member of the registered acknowledged bar by the Supreme Court. So they just have to be a lawyer. And right now, like Chief Nuss mentioned, currently Supreme Court justices have to have 10 years of continuing legal practice in the state. That's in statute, right? That's just in statute, which is created by the legislature. I say that to highlight that if we were to create this election process, they could get away with almost all, or they could basically remove any other type of qualifications. They could add qualifications. It would really be up to the legislative branch. Next slide, please. And then this is the part of the statement that really highlights what a vote yes looks like, right? A vote for this proposition would give Kansas citizens the right to elect Kansas Supreme Court justices as provided by law. Justices will hold offices for terms for 6 years. The nomination commission, whose membership consists of a majority of lawyers, as they like to point out, would be abolished. Now, this doesn't highlight that we already have retention elections, right? It does make it sound as if currently we don't have that right of that process, but we do. As well as just to remember, it's a simple majority on that Supreme Court nomination commission. There's 9 members. There's 4 lawyers elected from each congressional district. There's 4 non-lawyers appointed by the governor. And then there's 1 lawyer that's the chair, and they don't really have any special power. It just, it doesn't help when you create a governing group that is even numbered. So the next slide, please. So this is the last paragraph that will be on your ballot, and this is how it describes what a vote no or a vote against this proposition would mean, where they would be removing the Kansas Supreme Court Nomination Commission, because that nomination commission, again, a lot of this language is written in a way because in 1958, when Chief Nuss talked about the triple play, Kansans were so outraged by the political scheming and corruption that was displayed, they put this in the Constitution. They said, hey, we are going to have a merit-based process and we're going to have retention elections. So much of what this ballot amendment does is strip what Kansans democratically built in 1958. And this, basically just goes on to describe that, as well as that justices will no longer face retention elections if you vote no, or they will continue to face retention elections, which are when we get to decide if we keep them or not. So another really important part of this statement, right? Because this is the end of the ballot statement, right? Did anyone read anything about the lifting of the ban on justices receiving campaign finance or affiliation with political party? Anybody see something I didn't? Interesting, right. I wonder why folks within the ballot language created something for us to vote on and didn't mention that by voting yes, they would be essentially allowing Chief Nuss or anybody, if he were running for any type of Supreme Court position, that they would now be allowed to take money or hold political office. That's the sneaky part of this bill, right? Because if we want to go back to the August 4th amendment, right? This bill or this amendment was created by Senate Resolution 1611. 1611 is like the fine print of what all they're stripping in regards to if the amendment passes. Now, it just conveniently got left out that if this amendment passes, it would remove the current prohibition on receiving campaign finance money, holding political office. So that's just something I think is really critical for voters to know, since it's not going to be actually in the ballot language itself. It's essentially you have to read Senate Resolution 1611 to see that language. And that's really important because that's the crux of what opens the door. Like when we say the statement opens the door to partisan elections, that's on top of everything else the language includes, that's truly one of the most critical pieces that if we vote yes, it would create. So can I get a slide again? Yes. So just to describe again what a yes vote would do, this would remove the Supreme Court nomination process, ending our Kansas merit-based selection process. Any future vacancy on the Supreme Court would be filled by direct elections by Kansans. Those elections would be provided by law, created by the Kansas legislature, however they see fit. Candidates for Supreme Court justice could receive and spend political contributions, hold political office, engage in partisan activity. That's because it, again, lifts the prohibition on that activity if we vote yes, as well as it removes any guarantees that merit and legal qualifications would be considered in partisan elections, right? That would essentially, the situation I give is, hey, if there's a political party and they have a friend and they're like, hey, Jeff would be awesome on the Supreme Court, but he hasn't been a lawyer for 10 years, right? Or Jeff, he's from Washington, D.C., he hasn't been in Kansas, we'd really like to get him. If I know enough people in the legislature, know enough powerful people, we could curate the qualifications just for Jeff, right? So that's essentially part of that process of which we would be granting the legislatures to remove much of the rules or regulations or qualifications for justices. Vote no. So if we vote no, this protects the current Supreme Court nomination commission in the merit selection process. It would continue the prohibition on Kansas Supreme Court justices from engaging in partisan politics, parties, and accepting funds from special interests, maintains the democratic check of retention elections for the first year after their appointment, and then every 6 years after Kansans vote to decide whether to keep or remove Kansas Supreme Court justices. And I think this point's really important to highlight as well, that organizations and people will still be able to campaign and educate the public regarding whether or not to retain Kansas Supreme Court justices. Right now, any organization, any entity can spend as much money as they want to educate the public about whether or not to retain justices, right? So whether to keep them, should they keep their job or should they not? And that has happened, right? There have been efforts where there have been specific justices where a certain constituency group disagreed with the decision, so they were like, hey, we think they should be removed, but ultimately, Kansans still get to vote, right? So that proves the point that we have a merit-based process that has ultimately been affirmed by the vast majority of Kansas voters because we've retained these justices. The next slide. So why now? Why is this question before us? Next slide. So a really big concern is dark money and its influence on our elections. That's one of the most, I think, salient issues across all political elections, not just decisions whether, it's a ballot amendment or a justice, but the justice system is a unique example of a system that we have had in Kansas, at least, that's been insulated from money in politics, right? Just to highlight some statistics, in 2022, there was $20 million spent in just that ballot amendment alone, that question. Most recently, in the Wisconsin Supreme Court election in 2025, that cost $114 million. And here's the real thing. Out-of-state funding totaled 45% of the money spent in that election. So, I understand the potential, argument of, we'll have elections and people can vote. Well, we already have retention elections. But then when almost half of the money spent in these elections is coming from out-of-state forces that want to select our justices for us or want to influence the vote, that doesn't seem to be a very, qualified process by which we should govern and have an impartial branch, especially as vital as and important as the Kansas Supreme Court. And that's just a decision we have to make as voters, is if we are accepting of that potential and that known threat to influence over our, campaign finance. And ultimately, the Kansas judicial branch is built on independence and impartiality, allowing the influence of money and partisanship to hold sway over who gets on the bench could undermine our trust, right? I think there's a really interesting case in Texas where it was, I think like Pennzoil versus Texaco versus the state, where there was a situation where Pennzoil, this oil company, was being sued, and they made some very interesting campaign donations to justices during this court case. And the justices ended up ruling in favor of Pennzoil. And was there a written record where Pennzoil and the Supreme Court justices were like, thank you for this money, I will be voting this way, or I will help decide this way? No, right? And so we don't know for sure if that truly happened, if something nefarious or concerning was at play, but the public perception of the court was affected, right? People's view of how impartial, how free and impartial is our court system if this undue influence is allowed to exist. That has happened in these states with partisan elections, and it's a very real threat that we should be aware of as Kansans when we're making our vote. And the final slide. And this is very interesting, right? So I would suggest, I really love reading it because, as I mentioned in my bio, I love all things Kansas. There's this Fort Hays State survey, it's called Kansas Speaks, where they survey Kansans over a host of social, political, cultural issues. And they poll people, and they polled Kansans for about 10 years, where they asked them, what is the average job performance rating of all of your elected officials? Because Supreme Court justices are still elected just through retention elections, right? And overall, out of all the elected officials, the Kansas Supreme Court justice system had the overall best average rating compared to every other entity. And from how we've described it, I think that's very compelling. If we see that there's so many retention election votes where we keep retaining justices, when polling's done, people are supportive of this system. It helps illustrate that right now, it's a very important question to ask, is why would we change it? Why would we change it? So thank you so much. And also we have outside on the table, there will be some additional materials that Kansas Appleseed has pulled together for additional homework. There's also some really, I think this question, this ballot amendment brings up a really interesting opportunity to read up on what the founders said of America about the impartiality of the judiciary, as well as a little bit of the history around that triple play that Chief Nuss talked about, a timeline of the court. And for me, whenever I hear descriptions of the Supreme Court Nomination Commission, the first time I heard it, I was like, that sounds like a lot. How's that all interplay. We have a document out there where we try to graphically describe how the Supreme Court Nomination Commission works. There's also a QR code where it links to the application process. If you're interested in being a justice, like it's the application that gets sent to all these lawyers that are eligible. It's intense. So I would just suggest reading it because it's very fascinating. But I think we're ready to go with Q&A. So thank you so much.
All right, I'm just going to stay right here, but I do want to, before I saw several of you taking photos of the slides, thank you for paying attention to those. We will be posting those slides on the YouTube page at the time that this recording goes up. So just pay attention to that. Use those to your advantage when you're talking to your friends, your neighbors, anyone and everyone, to educate them on this. All right. We have many good questions here. Let me see. Well, let's start with this one. So how many other states have a merit system? And you could flip that around. I know obviously we talked about, and many of us probably remember the Wisconsin election recently, because that's recent and that was big. But how many have lately changed to elected versus what we have here in Kansas? And how many have a Kansas-like system?
I believe, so there are partisan elections, nonpartisan elections for justices. There is merit-based selection commission models, as well as models that are appointment-based, so they reflect like the U.S. Supreme Court. I want to believe it's over around half of the states have some form of commission by process, right? And I don't think there's really been a recent change with how they're appointed, but I would say it's about half. And a lot of them, interestingly enough, they're all in the Midwest. There's a lot of Midwestern states that I believe have this merit-based commission, helps narrow the appointment process down, and then a retention election.
Does the current committee have a set of guidelines and policies they follow for selecting candidates? And if so, how are they governed? And when changes are needed. So how does that happen if there are any changes that are needed to, if I'm following the question correctly, changes to the selection process or changes to the committee? So basically, do they have a set of guidelines that they follow?
I'm not aware of any written guidelines, but what they're guided by themselves is they want to pick the best possible justice that they can, or the best 3 names to send to the governor, who then in turn makes that choice. And the reason you have a mix of lawyers and non-lawyers on the commission is so they can bring various points of view with them, but they all agree upon that basic criterion, which is we want the best people that we can, because this is going to be for 3 million Kansans, almost 3 million. And one of the things that I find helpful in that process, and I made a little bit of allusion to it earlier in my remarks, but the commission members who will contact others to find out what's really going on with a particular candidate. I mentioned this trial judge called me and said, hey, Lawton Nuss, a commission member, a lawyer, just called me to get the lowdown on you. And I was surprised because I had not listed that judge as someone to give information about me. I can tell you later from my personal experience is after I was no longer on the court, I got a phone call from a woman who was on the nominating commission, a non-lawyer. And she said, I'd like to talk to you about candidate X. He has not listed you as a reference, but he has mentioned that he has argued cases before the Kansas Supreme Court. So I would like to find out from you what you think of him. And I said, well, I will talk to you about what I know, and I gave her information. And she said, thank you very much. This really helps me in my position as a commission member, because I believe each of them is assigned a candidate or two or three, depending on how many applicants there are, to do this check. And they will talk with judges, they will talk with people like me, even though we're retired, they will talk with the references, they'll go outside the references. For example, if you put on your application that you used to be the chairperson of the Salvation Army Advisory Committee, they will do some digging in where you're from and find a member of that advisory board and talk to them. What's this person like in a group setting? Are they a team player, or are they just going to be arrogant and selfish? So I don't know that that answers your question specifically, but the commission, now that they have another opening on the Supreme Court, Chief Justice Marla Lukert has left the court for health reasons. And as a lawyer, I got a notice several weeks ago notifying me that the commission is going to be having what I call an administrative meeting to talk about how things are going to proceed once they get these applications in, who's going to be assigned, that sort of thing, and then when they're going to start conducting their interviews. So it's a very, very orderly process, and it's a team process.
Just briefly, because I wanted to, that's why I was on my phone, was to make sure I was going to repeat everything correctly. On the website for the Supreme Court Nomination Commission, there is a set of criteria. I'm not sure if this is in statute or if this is determined kind of collectively by that body, but the Supreme Court Nomination Commission reviews justices. They look for a person's legal and judicial experience, educational background, character and ethics, temperament, service to the community, impartiality, respect of colleagues, as well as their overall judicial conduct.
I might mention, kind of connected to that, for several years when I was Chief Justice, the nominating commission would ask me to come talk to them about what I would be looking for in a colleague. And I was using a baseball analogy earlier when I said I was batting 0 for 3 in my applications, batting average 0. I used another baseball analogy when I talked to the commission, and it was different commissions each time, different members. And I said, in baseball terms, I want what's called the 5-tool player, somebody who can do it all. For example, yes, we want people who are impartial and are fair and are smart and hardworking, and they're willing to stay there until they get the right answer. But I also mentioned there is more to this position than just sitting in your law library writing opinions. You are a chair of a local nominating commission for judges, and you go out as the chair and sit through those interviews and guide the process. You are also the liaison for the court to a number of commissions. The Continuing Legal Education Commission, every lawyer is required to have so many hours of legal education every year. There's a commission for that. The licensing of lawyers, the bar exam, there's a commission for that. There's the Client Protection Fund Commission, where if a person feels that a lawyer has done them wrong and it costs them money, they can make demand on the commission for payment. And I know about these commissions pretty well because I happen to be a liaison for a number of those when I was on the court. And then you're expected to go out and give speeches when you are on the court. The court goes on travel dockets. They were in Alleen just a couple of weeks ago at the Eisenhower Center. It was open to the public. They heard 2 cases being argued. And so then there's a reception afterward to meet the justices by the public. And if you have a 0 social personality, that's not what we're looking for. So those are just some of the things that also come with this position. Yes.
Out of curiosity, this ties right into what you were just talking about before we move to the next
Question, how long do the nominating commission members serve generally?
I think it's
If you know,
I was going to say 4 years
4
is my
years.
Okay,
recollection,
okay.
yes.
4 years.
Yeah.
perfect, thank
So
you.
there's,
And I was-
oh, sorry.
No, you go ahead.
I was gonna say they're staggered, so there are at points, like it's not as if, you know, when a new governor is elected, they don't get to like flush out all of the nominating commission members. If they serve that term once they are appointed.
And I think I noticed that if you look at the website, you can see who all the commission
Yeah.
members are, and you can see when they were appointed, when their term is done, all of that.
Yep.
All right, so for either of you, and we got a couple of this question, so I think, and this is one of the questions I also wanted to know. So what are the proponents of Senate Resolution 1611 stating as the reasons to support this amendment? What are their reasons that this is the best way to go and people should vote for it?
You were just at a debate
So the
last week.
counter-arguments,
So you got to
yes.
hear
Yeah.
firsthand what their arguments
Yes.
are.
So there was a large amount of focus on the lawyers having too much control of the commission. I think you can even read it in the way the ballot language is written, right? Because as I mentioned, the ballot amendment was created by the legislature, right? And the folks who testified in support of that, they had their hands in crafting it. So even when you see the through line of like the majority of lawyers aspect of the commission seems to be a hang up for them. I think there's this idea that there's essentially an overvaluing of the role of the lawyers on the fact that they also believe that retention elections are not as effective as candidate partisan elections. So that's just a question to be asked, right, is whether or not those retention elections where Kansans vote to decide whether or not they affirm this process is effective. I would say there's also they pointedly, even in their testimony behind this, they want more partisanship a part of our justices, right? Like they want them to vote in a much more ideological manner that is like a very clearly for the public record stated. So that's a matter of whether we think that is right. But that's what they've stated, is that they would like more partisanship in that process. As well as, I mean, it was also supported by the Americans for Prosperity, the Kansas Chamber of Commerce, and a number of other industries. So I'd imagine there's also an interest in campaign finance as well, because currently a lot of those entities can't bankroll campaigns. So there would be a significant interest in industry, in, you know, industry's always looking out for themselves, rightfully, you know, their profits, and so they always are trying to see how they can donate to campaigns.
If I could just, again, as I did in my remarks, give you my experience with non-lawyer commission members. As I said, I got to be interviewed by 4 different commissions for the Kansas Supreme Court. And it was 4 lay people, non-lawyers I should say, and 5 lawyers. This was an equal partnership from my observation and my experience. The non-lawyers were actively engaged. They weren't just sitting back with their hands folded like this saying, oh gosh, the lawyers are monopolizing and dominating everything. I'm just a cardboard cutout. As I said, this one woman called me when I was no longer on the court because she was investigating somebody who was a candidate. And I never saw any shrinking violet on the commission. They were very active. They were asking questions as hard or harder than some of the lawyers there. And if you say, oh, well, Chief, you only did this 4 times with the nominating commissions, what do you know? Well, let me tell you, as I mentioned a few minutes ago, one of the extra duties that every justice has is to go out to the districts in Kansas where those district court judges, trial judges, are under the merit selection process. So they have nominating commissions. And I was always a non-voting chair, and I sat on different nominating commissions in Douglas County, in Kingman County, in McPherson County, in Saline County, in Cloud County, and Lincoln County. Different commissions made up of different people. And I never saw any evidence that any lay, non-lawyer member of those commissions was intimidated and just didn't feel like they could fully participate. And to hear somebody say, oh, they're just being monopolized and intimidated, I can tell you my evidence from being the person being asked questions and my evidence bringing out to all these local nominating commissions, that just has not been the case. And frankly, I've got to tell you, it's insulting to the people on those commissions who are not lawyers to say you're just here to keep your mouth shut and keep your hands folded and then you're dismissed. No.
That's good to hear. So thinking about that process that you went through, Chief Justice, how did going through the process and then witnessing that functioning over time with this commission impact your effectiveness as a Supreme Court justice? How did that, going through all of those?
Well, I will tell you that the person who, the third time I applied for the Court of Appeals and I said I was not appointed by the governor, somebody else was, that was a man named Lee Johnson. And Lee Johnson then got on the Court of Appeals, and he later became my colleague on the Supreme Court. And that something similar happened as well. When I got appointed to the Supreme Court, one of my competitors was a woman named Marla Lukert. I was appointed, she wasn't. And then she later went through the process again, and she was appointed to the Supreme Court. So Marla Lukert and I were colleagues on the court for 17 years. Lee Johnson and I were colleagues together for about 15 years. And I would just look at them during our case conferences and other things that we were doing and say, I know exactly why you're on the court. You're smart, you're engaged, you're hardworking, you want to get the right decisions for Kansans, and you are not afraid to make decisions that people are not going to like, because those decisions are required by the law to be made. And you're not up here just to say, well, gee, I wonder how Logan would like for me to come out on this case. That just doesn't go on. And when I knew that they had gone through the same rigorous process that I did to get to where they were, it just gave me a lot of confidence, and that got affirmed each time I dealt with them. And their tenacity, they lost, and then they applied again and got appointed. And one thing I'd also mention, if I could, Carol Byer is the one who beat Lee Johnson for the Court of Appeals position. She later got appointed to the Kansas Supreme Court as well. But the point I want to make is she was appointed to the Court of Appeals by Republican Governor Bill Graves, and then appointed to the Kansas Supreme Court by Democrat Kathleen Sebelius. The same held true for Lee Johnson, appointed by Republican Governor Bill Graves to the Court of Appeals, and then to the Supreme Court later by Democrat Kathleen Sebelius. And the flip of that was true for Marla Lukert. She was appointed to the district court in Shawnee County by Democrat Joan Finney, and then appointed later to the Supreme Court by Governor Bill Graves, who was a Republican. So there just isn't any politicking going on here, folks. It's the governors making the decisions they think are best for the state of Kansas, regardless of political affiliation of these candidates. Okay.
All right, I think we have time to combine maybe this one more here. So if the process changed, what are some of the entities that could also be changed? Are there other impacts of this appellate district, will the processes be different? How would a yes vote versus a no vote change other selection processes?
Besides for the Supreme Court?
Would it have any impact beyond that? Would we have two different processes then?
I'm not sure what you mean, two different processes.
Well, would we have different processes for appellate and
Okay.
district?
Okay.
We're going to change those.
As I mentioned in my remarks, the Kansas Court of Appeals used to be merit selection, but because they are not a constitutionally created court, the legislature can do whatever it wants with the Court of Appeals. And so even though they used to have merit selection, the legislature a few years ago changed it, and now it is the governor just appoints whoever she wants. And let me back up just a little bit. She makes an appointment, and then the Senate in Kansas has to confirm. So it's what we would call like the federal model. Well, Governor Kelly took that statute from the legislature, and she, in my view, made it better because she said, you know what, I'm going to have a nominating commission that I'm creating just because I'm governor. It's not binding on anybody else but Laura Kelly. And so she has appointed people on that nominating commission. They go through the same process, the application, the interviews, then she makes, and then they narrow it to 3 finalists. Those names then go to the governor. She interviews them. She does the background checks through the FBI. Her staff interviews them. They do their own independent investigation on top of what the commission did, and then she makes her selection. So the legislature could change that process in some fashion. I don't know what it would be, but it may be that we're just not going to have the governor making those appointments. The legislature will decide who the next judge is going to be for the Court of Appeals.
But they could
Or
make
the
that
Supreme
choice. They could change that right now.
They can do that, yes.
That's not dependent on the amendment, yeah.
But if this, yeah, right.
I think one of the big questions we have
That's important.
related to the amendment is, especially in that ballot language, and it says provided by law, one of the really big questions is obviously around campaign finance. I think another big question is around the creation of districts or statewide, right? That has a lot to do, I mean, think of any conversation around redistricting and gerrymandering, like you would essentially be, if it's not statewide elections, you would be creating new lines that alters representation dramatically. Would you just have it based on congressional districts? All of these are choices that would have to be made. So if this amendment passes, I would expect to look at the 2027 legislative session, and there will be a flurry of legislative activity in the creation of what this model of elections will look like for justices if this amendment passes in August.
I want to say something before we sat down, if I may, but if you have a question, do you want to
I
ask us?
think we've got a couple of additional items that we
Okay.
will close
Okay.
with, but if you'd like
Let me
to
just mention this,
add one more item.
because I think it's important. Texas elects their Supreme Court justices. I'm sorry. Good morning. Welcome to the Texas elects their justices on their Supreme Court. I know 3 of their former Chief Justices, and they all oppose that system. In fact, while he was Chief Justice, a man named Wallace Jefferson, the Chief Justice of Texas, wrote op-eds for the Houston Chronicle and the Dallas Morning News saying he opposes that system even though he grew up with it. And the system he wanted to replace it, merit selection. I've had conversations with 2 other former Chief Justices of Texas. They also oppose it. They have spoken out against it. And let me close with this. This is by an article by Sue Bell Cobb. She was the former Chief Justice of the Alabama Supreme Court. This is an article that she wrote in 2015. I was Alabama's top judge. I'm ashamed by what I had to do to get there. The subtitle is How Money is Ruining America's Courts. I felt trapped. I had made it to the top of my profession. I was the Chief Justice of Alabama, the first woman to head the state Supreme Court. It was, for a lawyer like myself, the pinnacle of achievement. To get to the justices' chambers, I had won the nation's most expensive judicial race that year, but at what cost? And she said, a reporter from a national legal publication called her immediately afterward and said, Judge Cobb, how does it feel to be the victor of the most expensive judicial race in the United States this year? And how can you assure the people of Alabama that the contributions you sought are not going to impact how you rule? And how can you convince the people of Alabama not to believe that their courts are for sale? The reporter's questions were valid in 2006, and they still are. How do we convince Americans that justice isn't for sale when in 39 states it is? So.
Okay, well, thank you all for coming. We have a couple of quick announcements that we'd like to make here before you depart and enjoy the rest of your Saturday. So I'm going to welcome Alleen. Oh, no, you. It's your announcement.
Oh, okay. You scared me there for a minute.
No.
What did I forget?
No.
What is today? What did I forget?
We're going to be quick.
I do have one important announcement to make, but I do have a couple of comments based upon what was said here today. First of all, one of the things is you'll be reading in the newspapers about the Missouri plan, off and on, and a lot of people will, well, how is that different? That basically is not different. The Missouri plan is the same plan we have, with a few bells and whistles, but pretty much the same thing. They beat us to it. They got there in 1930. Their voters were asked twice in the next 15, 20 years, let's do away with this, same situation. And in both cases, the Missouri voters, in huge numbers, said, leave it alone. So we're not alone here, and as you said, as they just said, 30-some other states are in the same situation we are. And, my thought about that, well, is if something's not broke, well, don't tear it up. The other thing I did want to point out is Justice Nuss was talking about the phone calls you get. Well, I'm a practicing lawyer, and in 45 years, I've gotten a bunch of those phone calls, too. And sometimes they're from other lawyers saying, well, what do you think about, you've been in court with this guy, what do you think? But I'd say about half of the calls that I've gotten, there's been a lot of them over the years, they're coming from the non-lawyer members. And I tell you what, their questions are the toughest. And the ones that sticks in my mind the most is from this person who said, well, I see where you live, and you don't live very far from this guy. How's he behave when he's home? Well, I fortunately was able to answer that question. But everything they said rings so true about the composition. And, having gotten those phone calls, I had the same experience. Now, I do have a very important announcement today, and I want to say that I'm glad to be able to make it. In March, the State League adopted a position on this amendment. And I'm not going to read the entire thing. I'm going to just read the one paragraph, and you'll see more of it. It'll be printed in the voter when you get it. Pardon? Then the announcement is that our league will comply with the position that the state league has taken. And that position is this: the League of Women Voters of Kansas opposes the elimination of the Supreme Court Justices' merit-based selection system. We recommend that voters vote no on the constitutional amendment on August 4th, 2026, at the primary selection ballot. So bottom line, we got one position. We got one position statement, and it's very complicated. Vote no.
Thank you all for coming today. I know we didn't get to every question, but if you would, we'll reset the room here. We'll conclude our program today, and you can visit out in the lobby area. Thank you so much for spending part of your weekend with us. We appreciate you being here.